Hi, my name is Courtney Brennan, and I'm an associate in the Burns-White Litigation Practice Group, where I focus in the areas of employment, business, and complex and commercial litigation. I hope you enjoyed this segment from a recent webinar, and I hope that you find it helpful. As we turn to the current policy considerations in determining whether you as an employer should mandate the COVID-19 vaccine or stick with a more voluntary program, there's a couple of threshold questions to consider. And the clients that we've worked with all have chosen to take the approach of a voluntary program focused on educating and encouraging employees to get the vaccine. Obviously, a highly vaccinated workplace will reduce the likelihood of stoppages and can generate more of a returning to normal feeling amongst employees who are transitioning back from remote working. With a mandatory vaccine program comes engaging in what we call the interactive process for employees who might be requesting a medical exemption from the vaccine under the Americans with Disabilities Act or the ADA, or employees are also able to request a religious exemption under Title Vii. So these two exemptions and the process with which employers engage in the interactive process is certainly something to take very seriously, as missteps by an employer or missteps by supervisors could certainly expose your organization to liability. So it's important that we understand the parameters of these exemptions and what is covered and what is not. So beginning with the medical exemption, obviously some individuals have allergies or certain medical conditions that make it unsafe for them to take the vaccine. Now, under the ADA, if an employee claims to require an exemption based on a disability, a workplace has to engage in the interactive process in order to come up with some type of reasonable accommodation, if possible. Essentially, employers should recognize that the ADA does not create an automatic right for anyone to just opt out of the vaccine if you're choosing to mandate it, but it only guarantees the right that you will engage in a fair and interactive process that leads to some type of reasonable accommodation. This is very fact specific, and these determinations are made on a case-by-case basis. Basically, what we know is that these types of accommodations can look like, allowing an employee to not get the vaccine because of their disability or need, but to continue working using the appropriate PPE, continuing to social distance, and deciding whether or not continued remote work could be an option for that specific employee. Other possible accommodations could include shifting the unvaccinated workers to another role or position if one's available, maybe even relocating their office space. But those are the types of decisions that employers need to at least consider for employees who are asserting an exemption under the ADA. The second major exemption is an accommodation based upon a sincerely held religious belief under Title VII. Now, under Title VII, those such beliefs have to be taken into account. As long as it would not pose an undue hardship, reasonable accommodations must be granted. The EEOC has made it very clear in their recently issued guidance in December that employers are only obligated to accommodate sincerely held religious beliefs. So it's important to remind employees at the outset that social feelings, political beliefs, scientific, any type of non-religious view is not protected under federal law, and it's not a sufficient justification that that employee can use to kind of work through the process. So again, it's critically important how employers communicate with their managers and their supervisors, because any misstep could lead to claims for constructive discharge, wrongful discharge, and retaliation. In terms of practically implementing these types of policies, employers want to start thinking, if everyone hasn't returned to work, informing employees of what your intentions are regarding the vaccine in advance, so that employees are able to ask questions and make these types of decisions and not be taken off guard upon returning to work. Again, preparing managers to understand a request for an accommodation and knowing that they have to appropriately take these requests up the channels. Courts don't require employees to use magic words, quote unquote, I'm requesting a reasonable accommodation. So courts will interpret the things that employees say quite broadly, and that's why it's so important that the individuals who are speaking with these employees don't downplay a request or just simply ignore it, because then you could be on the hook for these. One of the common questions that we're starting to see as people get vaccinated is whether or not they still have to wear masks, whether social distancing will still be required and other measures. As of right now, the CDC still has those measures in play, even if you've been vaccinated and until everyone has been vaccinated. So for the current time period, it's advisable to keep social distancing in play, continue to wear masks, and do your part until we have more guidance. But in the long run, providing a prospect to return to work in a relatively normal type of environment is certainly a powerful force in not only boosting morale in the workplace, but getting greater buy-in amongst your employees. Considering what types of litigation could arise from the vaccine, we're monitoring the first case that has been filed by an employee against their employer for mandating the vaccine because of the emergency use authorization, which states that people have to have the option to accept or refuse administration of the vaccine and be informed of the consequence of refusing the vaccine and the consequences of that and any alternatives. Based on everything we know, this employee's argument is not likely to be successful, but employers should still be aware of the types of risks that are involved in mandating the vaccine. What makes this current situation distinguishable from past pandemics is obviously the fact that this is the first time in history that we're operating under the FDA's Emergency Use Authorization, or EUA, as you'll see it, as opposed to the full-fledged FDA approval. Now, there's no indication that courts will view this any differently than the fully approved FDA vaccines of the past, but this issue nonetheless still appears to be one of first impression. However, when and if that time comes that the COVID-19 vaccine receives full FDA approval, employers will be able to rely on a well-settled body of case law that have upheld the use of mandatory vaccine programs. And the EEOC a few months ago came out with newly issued guidance backing up employers' ability to mandate the vaccine if it's appropriate for them. But we can obviously imagine the possibility of more claims being filed by people who are refusing to receive the vaccine and are arguing retaliation of some sort or wrongful discharge because we are operating under the emergency use authorization. So these claims are unlikely to be successful given the past precedent, but still things to be aware of and keep on your radar.